From Hamilton Place Strategies in Washington, D.C., this is the HPS Insights podcast.
Welcome to HPS Insights, a regular podcast from Hamilton Place Strategies, analyzing the current events impacting the business and political communities. I'm your host, Lloyd Miller, Senior Director and Head of our Analysis Practice at HPS. Today, we'll take a deep dive into the privacy policy debate and how we got here. This week, I'm joined by our guest, Alec Stapp, Director of Technology Policy at the Progressive Policy Institute. Alex, thanks for joining us.
Thanks for having me.
Yeah, so why don't you talk a little bit about how you got into policy and the work that you're doing at PPI?
Yeah, about 3 years ago, I moved from Arizona to Washington, D.C. to do a master's in economics at George Mason University. And as part of that 2-year master's program, I was a research assistant at the Mercatus Center, and I was, looking around for what public policy areas I was interested in researching. And I noticed that I had a personal interest in technology and how it impacts our lives. And I also realized that it's one of the biggest ways you can actually improve people's lives. So if you can maximize innovation, increase economic growth, that's one of the best ways you can increase social welfare. And I got a summer fellowship at the Niskanen Center between my first and second year to work on technology policy. And then I just continued on that area, in particular antitrust and data privacy, because there are really active debates that are in the news a lot, and I wanted to be at the forefront of those debates.
Well, that's great. So talk to me a little bit about the research that you've been doing at this point up on policy, and specifically about the two biggest privacy policy pieces of legislation that we've seen in the last few years in GDPR in Europe and CCPA in California. Yeah,
those are definitely the two biggest, most salient pieces of legislation out there that will be used to guide any potential federal privacy legislation in the future. GDPR, we're going up on the 2-year anniversary in May this year, so it's been in effect for quite a while. And I've been tracking that, looking at the costs and unintended consequences of that bill, because I think people had a hope when they passed it that it would achieve certain privacy aims. And I think we can discuss this more in detail later, that it's fallen short of some of those aims. And then there are a lot of unintended consequences that people didn't anticipate prior to going to the bill. At least the people passing it didn't, but maybe some commentators.
Yeah, just clicking, yes, I accept cookies constantly is one of the weirdest things to see the whole internet change right after GDPR came in.
Right, yeah, we definitely have GDPR to thank for that. And then I think the average person's experience on the internet doesn't feel any more private or any safer, because they just realize it's annoying. I always click yes, I accept. I'm not even sure what happens if I click no. Some websites don't allow you to access their content if you click no. Some do. That's actually still an open question whether that's a breach of GDPR, if they're pressuring people to say yes or not, what kind of consent they're allowing. But at the end of the day, GDPR is a consent-based model. It uses opt-in consent where users have to affirmatively opt in to the privacy regime that a company uses. But after that's the case, companies can do almost whatever they'd like with it, or at least similar practices as they were doing before GDPR. And so a lot of privacy advocates who want to see more extreme measures have been disappointed by this, because they're realizing Facebook, Google, the biggest tech companies aren't changing practices. They're just getting their users to opt in and consent to what they were doing before.
So speaking of changing practices, one of the things that's been interesting to me is the concept of discrimination in privacy legislation. It's something that especially you see EFF on the left and a lot of consumer groups really strongly advocate for the idea that whether or not you opt in or opt out, it shouldn't change what services you are provided. Does GDPR address that, or is that kind of the area where you were talking about there's just this big gray area?
Yeah, so both GDPR and CCPA, which went into effect January 1 of this year, address discrimination. And this is, CCPA is actually the most interesting part of this, because it's internally conflicted on this point. In certain parts of the legislation, it says that if someone opts out, you have to treat them the exact same. But then in another part of the legislation, it says that companies can offer discounts and incentives for users to share their data, which seems like you might be treating your customers differently, whether they're sharing your data or not. But I'm putting on my economist hat right now. The idea of discrimination is key to preventing a free rider problem. And by free rider, I mean that if a user can opt out of sharing their data with a company and receive no negative consequences, they get the exact same product and service, same quality, then they have no real incentive to share their data. They might think I don't care about privacy that much, but why would I give my data away? Maybe something bad might happen way down the line that I can't predict. And so the easy option is to say no, and then you get the same service. Well, most of the internet is run on free services that are ad supported, or they monetize data in some other way. And so if you eliminate that kind of economic model, you're going to lead to users needing to pay for services more than get free services right now.
Well, that's interesting. So with CCPA, how much of what is in CCPA as actually rules and laws that are into place and affecting businesses now, and how much has kind of been kicked down the road to the California Attorney General to be able to write those rules?
Yeah, so actually a lot of it's been kicked down the road, and I think this is part of how the bill came to be. If you understand the legislative history behind this text, you'll understand why still a lot of it is to be determined, even though it is the law of the land as of January 1 of this year. There was a ballot initiative in California about maybe more than a year ago now, backed by a wealthy individual who wanted to see greater privacy protection. And that ballot initiative pressured the legislature to actually pass a law in a very short period of time, less than 2 weeks. And so they realized, we'd much rather pass a bad bill through the legislature than do it through ballot initiative at the ballot box, right? And so you get this situation where they try to draft a comprehensive privacy package in less than 2 weeks. There are a lot of errors. I just mentioned one inconsistency with discrimination. There are many more. And they also kicked a lot of it down to the California State Attorney General Office, who will be enforcing this. And so they've already released 2 rounds of guidance on what these regulations, as implemented, might look like, but they're still... It's an ongoing process. They're soliciting comments from the public on this, and it's ongoing. And so businesses, both in 2019 and in 2020, are trying to implement a really complex, like I said, comprehensive set of regulations without knowing exactly what each term means or whether they're affected or not.
So CCPA is a California law. It's not a national law, but obviously some businesses are just like with GDPR, where even if you're in the U.S., you still have to click the accept cookies on every website you visit, because it's just easier to implement one policy than implement policies based on where a user is accessing your website. So with CCPA, obviously, this is the impetus for a national privacy legislation, is we don't want the patchwork of an Illinois law that does one thing versus a California law that does something else. So the first main component of federal privacy legislation, which I kind of want to get into now, is preemption, and the idea that federal law must be the rule of land and kind of eliminate the need for CCPA.
Yeah, and I think that's really important. I think it is the most important ingredient in any kind of federal privacy package. And the reason I think it's necessary, there'd be almost no reason to pass a federal law without preemption, is because from a public policy perspective, we try to think about the appropriate scope of legislation. So you want the law to match the scope of the problem or the scope of the economic activity you're trying to regulate. And so the internet, right, is a global phenomenon. So we want to regulate it at the highest levels possible. Because sometimes there are arguments for federalism or localism, where the local government might have more insight or better information in terms of regulation. But really for the internet, it's something that really should be done at the federal level. And so, like you mentioned with California, it's such a large state with such a big economic footprint. Most tech companies are based there. When they're creating policies, if California requires something, that becomes the de facto national standard. And so we really do need federal privacy legislation that can preempt California and other laws, because we already have one state setting the rules for the other 49. And that seems like a really inefficient way to do things from my perspective.
So speaking of preemption, the other concept is rescission that we just spoke about a little bit, which is how does a federal privacy bill overrule all of these existing privacy rules that we have with FERPA and HIPAA, and everyone's familiar with the idea that, a lot of your medical records should be treated privately, and that is a component of private data. So where do you think federal privacy legislation should fall in terms of overruling or just being a supplement to existing privacy rules?
Yeah, I think you're definitely hitting the most important points, and I would put rescission right up there. And I think in this situation, for laying the groundwork of the debate, I think people in the U.S. talk about how, in Europe they have GDPR, in California they have CCPA, and there's almost an assumption that everywhere else it's unregulated, which isn't the case. We have decades of legislation in the United States and in common law regulating privacy, in particular our most sensitive industries like education, healthcare, finance, that use the most sensitive data. And so those laws are already on the books. And so what I would like to see is, with rescission, not just piling on top of that. You run into a lot of problems where there are inconsistencies with laws. CCPA is actually having this problem as well. California had dozens of smaller privacy regulations in place prior to that, and there's been good analysis that CCPA is actually in conflict with them. So again, making it harder for businesses to actually be in compliance when they're making a good faith effort. So I'd like to see in the U.S. on the federal level that federal privacy legislation would supersede previous laws, but then the federal law, the comprehensive package, would need to account for sensitive versus non-sensitive data. So sensitive data would have higher standards for businesses for duties of care, and non-sensitive data would have less protections. And I think that would be the way you can mimic the best parts of our sector-based privacy regime we currently have while getting a more comprehensive universal system that all businesses can comply with.
Yeah, I don't know how you could possibly answer this, but how does a bill conceive of defining sensitive data versus non-sensitive data versus public data versus pseudonymous data versus biometrics and all of these different categories of data that are somewhat overlapping but also very ill-defined conceptually?
Definitely. That's why you need to spend more than 2 weeks drafting a bill. So I recommend not following California's approach there. These are really complicated questions, but I think at the end of the day, especially if you can both define different data types narrowly or just do your best, to get the most appropriate definition, and then also intersect that with the covered entities. So what kinds of businesses have this kind of data? And so I respect what ITIF, a think tank here in town, did when they released a draft of a potential privacy bill last year. They tried to both look at sensitive versus non-sensitive, those are types of data. Again, like health data would be sensitive, but what you search for might be less sensitive. And critical versus non-critical services. So that would be the kind of business you're interacting with. So a hospital, right, is a critical service, but your dry cleaner, not so critical. And then you would hold those to different standards as well, which I think would be the best approach to minimizing compliance costs for the lowest risk types of data and data uses, while holding the most critical businesses to the highest standards.
That's interesting because a lot of the bills that I've seen and a lot of the concepts that I've seen in terms of like ITIF's framework and a few others is defining not in terms of business sector, but in terms of business size. So the Wicker bill is a good example of it defines businesses based on the number of individual records. So I think it's 5 million is their threshold of individuals to be a large data business, or to be a small business, it's revenue under $25 million. So do you think that it's better to define by sector than it is by size, or do you think both work?
Yeah, I think both work. I think you could use an example here of GDPR versus CCPA. And I don't mean to say that there are no trade-offs whether you go one way or the other, because I think there are pros and cons to both approaches. So on the one hand, I think there's a rule of law question, like a small business can also abuse your data, and so why should they necessarily be exempt? And so I don't ignore that as a real concern. But at the end of the day, small businesses just don't have the compliance teams capable of necessarily competing with the biggest players on a regulation question. And so I think I prefer CCPA's approach on this, where CCPA says that if you're under 25 million revenue per year, you're exempt, or if you handle fewer than 50,000 people's data per year, California residents' data per year, then you're exempt from CCPA. Compared with GDPR, which literally says if you process any data of an EU citizen, whether you're even in the EU or not, you are liable under GDPR. I think that's just too broad a regulation that catches too many innocent uses of data in that process. And so that's that kind of approach. I would look for those kind of exemptions for small businesses and then intersect that with the type of business. So you can do both, I think.
So with all these businesses, like your dry cleaner example is really interesting. A dry cleaner could actually have your financial data, it can have your address, your phone number, some level of personal identifiable data. To what extent can you apply the concepts of data minimization into that? Because we can talk a lot more about breaches, and GDPR is basically a breach notification and finding tool. So data minimization and how that could be possibly built into legislation.
Right, yeah. I think I'm glad you brought up data minimization, because I think from my perspective in this kind of PPI's approach to public policy, we care a lot about innovation and maximizing innovation or making regulation compatible with innovation. And I think data minimization is one of these things that sounds great in theory, right? It's don't collect any more data than you need for the purposes you're pursuing as a business. But that kind of assumes that businesses know ahead of time, they have perfect insight into what kind of data they need for their current business and their future business. And so a lot of great innovation happens where companies have been collecting data or collecting any kind of resource, and then a year down the road or 5 years down the road, they look at what they have and they say, competition has increased. We need to get more creative. What can we do to increase value for our consumers? And they might end up using data in a way they didn't anticipate. It happens all the time. Or it happens in research, where interesting questions come up and researchers say, I could use data that's already been collected by other data sets by other researchers to answer this question, or I can go out and create a whole new experiment, undertake all of those expenses to pursue that. What's more efficient, what's more cost effective. And there are great examples where researchers have looked at data that's already been collected and used it for a new purpose. Are we going to limit that by having some kind of data minimization rule or purpose specification rule? I think there are really huge costs there. And I think, again, this is where if privacy is your only concern, then I understand why you want to have a rule like that. But in a society where we have different values that we're trying to trade off against, I'm much more skeptical of data minimization.
Interesting. Yeah, that's where I actually thought that there was a nuance in the Wicker bill that I enjoyed, was that it does have a data minimization provision, but also includes under the exceptions a fairly broad academic research concept where it also provides that exemption to like transferring data to third parties as well.
Right, and I think if you wanted to have some kind of minimization, I would want many exemptions for good uses as well. And I think on a broader principle-based perspective, I think this is we'll see how this is related in a second. That a harms-based approach is the best approach. So unless you can show that consumers have been harmed by having their privacy violated in some way that you can even just only roughly quantify, I think you get much more efficient regulation and enforcement. Because I just worry that these kind of rules will lead to businesses not doing enough, right? So data is a public good. We want more of it. We want to subsidize it. We want to make it more broadly available because we can do a lot of really cool things with it. And so I worry that these kind of rules would limit that too much.
Yeah, I think that's exactly right. And we'll take an opportunity to take a break here. When we come back, we'll take a look at the pitfalls and implications of the possible privacy legislation. We'll be right back. You're listening to HPS Insights.
You're listening to HPS Insights, a regular podcast from Hamilton Place Strategies. Be sure to subscribe to hear the latest from the HPS team on policy debates affecting the business and political communities.
We're back on HPS Insights talking about privacy with Alec Stapp. I want to turn now to talk a little bit more about the enforcement mechanisms involved in privacy legislation and then get into some of the economic consequences and trade-offs involved. So with enforcement, federal legislation obviously focuses a lot of the enforcement on the FTC. To what extent is the FTC equipped now to be able to handle federal privacy legislation, and what kind of resources or tools will they need in order to be able to handle this type of enforcement?
Yeah, I think the FTC has the expertise necessary because they've really been the top privacy cop on the beat, as I like to say, for the past few decades in enforcing general privacy violations. Section 5 of the FTC Act says that the FTC can bring enforcement actions against companies for unfair or deceptive practices. That's a very broad phrase that can be interpreted to apply to privacy violations or data security violations. And so I think the FTC has a lot of experience going after these cases. The key here is a resource problem. So in inflation-adjusted terms, the budget for the FTC has actually declined over the last few years. And so they're doing great with the limited resources they have, but especially if Congress gives them a new mandate to go after these in a more aggressive way or to enforce new rights that consumers might have in this area, then they definitely need more resources. But I think they're the right venue because of this institutional expertise they developed over decades to enforce existing privacy regulations.
That's interesting. I actually remember a piece by Nancy Rose talking about the same issue with antitrust and competition enforcement, where the size of the deals keeps increasing, but the budget for FTC to be able to investigate these hasn't kept pace. So you end up kind of with an underfunded and under-resourced organization trying to catch all of these tools at the same time.
Right. And I think, I appreciate you mentioning antitrust. That's the other area I work on most often. And I think in this case, the broad principle here you can kind of think of is if you like the current regime that makes different trade-offs between policy outcomes. So in antitrust, I think I'm much more satisfied with where we're at currently than to kind of head off public dissatisfaction with enforcement. You really want to make sure that the enforcers have the right tools, right? So if they're understaffed, under-budgeted, and they're not going after clear harms that everybody agrees are clear harms under the current rules, then they're going to demand change at a higher level, new legislation, new burdens on companies. And so I think you can get a much more optimal outcome if you give enforcers the right tools today.
Yeah, I think we all don't want to have to go through this again in 2 years
exactly.
or 4 years. So beyond the FTC, obviously DOJ has a role, and the state attorneys general also have roles in terms of enforcing any one of these data privacy rules. But what about citizens? What about you and me? What happens if my privacy is violated by a company? Do I have any sort of role to play in that?
Yeah, I think I'm much more skeptical of individual private right of action just because I think the compliance costs that the the companies have to deal with litigating those can quickly get out of hand. This is why we see often companies try to go through arbitration, just because the cost towards actually fighting things in the courts is way too high. And I'm going to bring this back to the harms-based focus of what I want to see in federal privacy legislation, because I think that if you ever try to quantify this in academic research on how much consumers actually value privacy, you want to definitely do it by type of data. So they value the privacy of their healthcare data much more highly than any other type of data. But even that is on the order of like dozens of dollars per month. Like we're not talking about like thousands of dollars per year or anything. And so if you want an individual private right of action, I worry that the litigation costs and the benefits would mostly accrue to the attorneys, and the benefits to real consumers would actually be very, very small. And so then I ask from a public policy perspective, is this whole pursuit worth it, right? If consumers actually aren't benefiting in a different way than if the enforcers, the FTC or the state AG, they can take on the burden of the investigation, impose fines or remedies on the companies, and actually curb behavior in a more effective way.
Yeah, this is where I've seen, I think Microsoft came out recently for some version of a private right of action, or at least open to the concept of it. But in my understanding, it would only end up being something that could be superseded by a state's attorney general or the FTC or DOJ. So it functionally turns into like a citizen petitioning one of those entities in order to do that enforcement, which I think is a good thing. Like people should be able to go and, petition their government to be able to take action, but not necessarily create those kind of, frivolous lawsuits or, ballooning attorneys' fees and compliance costs just related to being able to handle the inundation of private lawsuits like that. Yeah,
I totally agree. I think that's the better avenue for it, to have some kind of channel for complaints to reach officials so they know what's going on in the marketplace. It's just a classic knowledge problem of like, does the enforcer at the federal level, the state level know what's going on, what violations may or may not have occurred, and that's much better than I think. As a comparison, this may be a recent case that listeners might have heard about recently in the last few weeks. Facebook had to settle a $500 million class action lawsuit in Illinois for violating the state biometric law. And I did some quick math on my own to try to figure out how much each individual might gain from this. And it's actually pretty significant. It's like $200 per person in Illinois if every Facebook user in the state of Illinois ends up filing to accept their portion. So like, okay, that's a nice benefit. So the class action system kind of worked there. But again, from my economist public policy perspective, the violation there was that Facebook had a tool that allowed users on Facebook to automatically tag their faces in photos. And that violated the state's biometric privacy law because it didn't have the right opt-in for that tool. I'm extremely skeptical that consumers actually incurred $200 worth of harm from Facebook's free-to-use tool about matching your faces. And so I think that's a situation where the private right of action probably got us a suboptimal outcome for society.
Yeah, so speaking of the harms, what are the big trade-offs that we would have to take into account with federal privacy legislation? What are the things that we could risk losing if we enact this type of legislation? Yeah,
so I'm a little biased here, but I'm going to give you an antitrust answer to that question. So I think there's a huge trade-off between privacy regulation and market competition. And so we're seeing this, again, GDPR has been the longest-running experiment in comprehensive privacy legislation we have so far. But we're a little less than 2 years out now. And what we've seen is that it's only entrenched Google and Facebook. And I want to see more startups. I want to see tons of competition in the tech space. And historically, we've had that. But I worry that things like really burdensome privacy regulation might slow that down. And the key reason is it's two reasons, really. One, big companies in general, for any kind of regulation, compliance is a fixed cost. So I just need to hire the attorneys to write the privacy policy once. I need to hire a team of engineers to implement any kind of changes to the product once. And that's true pretty much in software for small tech companies or large tech companies. So right off the bat, the large tech companies have a competitive advantage on a relative basis for compliance. And number two, in privacy in particular, especially with the consent-based models of GDPR, where you're allowed to do almost whatever you want so long as you get the user to affirmatively opt in and consent, that redounds to the benefit of the biggest players who have a direct first-party relationship with users. And that's Google and Facebook. We all have accounts with those companies. We generally trust them, especially Google relative to Facebook. And if they give us a pop-up that says, do you opt into us doing X, Y, or Z with your data, 99% of people hit accept. But in the ad tech market, the small third-party vendors that are independent, 1/10 or 1/100th the size of Google and Facebook, they don't have that direct relationship. They can't get consent. And we've seen 20 to 40% decreases in volume on third-party ad exchanges. And we've seen Facebook and Google increase their market share since GDPR went into effect. And so it's really helping them on a relative basis in a way that's worrying to me from someone who wants to see more competition.
Do you think GDPR is going to be modified in any way to be able to address those concerns, or do you think what else is there like that they can do?
I know that they're having discussions. So GDPR is actually enforced on a country-by-country basis. So the National Data Protection Authority in each country receives complaints from users, goes about carrying out investigations, brings enforcement actions, and they have built into GDPR a kind of reconvening on a regular basis to discuss, like, do we need to make amendments? And I've heard that countries, Germany in particular, has some concerns about how things have been implemented. And I think they will do some tweaking at the margins that might make it better. So I'm excited about that. But in general, I think the whole model is set up in a way that cannot address the problem I'm raising, which is that if you have a consent-based model with affirmative opt-in, it's just going to benefit first-party companies with a first-party relationship with users. And there's no way to get around that, really, using that broad model.
As you talked about before, GDPR it's a blanket application. No matter what, if you deal anything with any EU citizen, it applies to you. Whereas the U.S. laws, what we've seen is creating those thresholds of certain amount of revenue, certain amount of user records. Do you think that will at least minimize some of the anti-competitive effects of privacy legislation?
It could, yeah. And again, I'd have to mention it because it's like in the back of my mind, it does still bother me that like you do really want rules to apply to everyone in the game. So I'm putting that out there. But again, I think the trade-off is worth it, that I do want to see these exemptions for small businesses because they are less able to easily compete with large companies on the compliance dimension. And so I think that would address some of the harms. But I think we've seen it poorly implemented in CCPA, right? So something like a $25 million annual gross revenue exemption. So if you're smaller than $25 million a year, you don't have to comply with CCPA. Seems reasonable to me, in the right ballpark. But then there's a second prong. It says, or if you process data for 50,000 California residents per year, you're also liable under CCPA. That's a really small bar for a lot of websites. I know blogs that get that many California residents per year, right? So in that effect, really that's the binding constraint on CCPA, and that seems way too low to me. So if we're going to do some kind of exemption, I'd rather just go with the revenue threshold, or at least raise the other bars to be commensurate with each other in terms of how many companies are catching under the rule.
Yeah, one thing I noticed with the Wicker bill is that it has that $25 million gross revenue threshold and a few other exemptions. Or qualifications for that, but also that it only excludes application to certain other provisions. So it's which are the individual. I think it's the individual opt-in and consent portions of that, which I think would create an interesting barrier. It's like, what happens if you're at revenue is $24,500,000? Do you suddenly, like, that barrier to hit that next 500,000, all of a sudden, okay, but then I'm going to incur $2 million in compliance costs to get the extra 500,000 in revenue. So it's better to stay smaller, or just get acquired by Google or Facebook or Amazon or one of the bigger companies that already has that compliance built in.
Yeah, that's a real distortion. And that's whenever you build in any kind of policy cliff or trigger into a regulation, you get the exact effect you're talking about there. And I think the key here is that compliance is a fixed cost. And so so when if you're making a decision on the margin, which is what entrepreneurs and management do, they're going to consider this huge fixed costs for potentially small amounts of revenue. And so you don't want to disincentivize companies to grow either. And so you can do something like you mentioned, like tiered. So you're only exempt from certain parts of the law. If you're of certain sizes, you could have multiple tiers where the most onerous stuff is at a much higher revenue threshold. So you can really tweak it in different ways. But the trade-off you're making is reducing compliance costs for a lot of small businesses while trying not to distort incentives on the margin too much.
So the last thing I really want to talk about is consumer implications and kind of how would an end user see changes in the way that they interact with the internet and their favorite applications, from Uber to Google Maps now versus after, what the broad strokes of what a federal data privacy legislation would look like. Where are the areas where people would see a decline in services or, no longer being able to use their favorite services. Like an example that I've always considered is what would happen to Google Maps traffic data if it is cell phone location sufficiently anonymized to be able to still be using that. Otherwise, you end up in situations where people can't use their favorite feature of Google Maps, and then it creates more opening for other competitors to come in. Or are there going to be exceptions built in for things like that?
Yeah. So since we're nearing the end of the podcast, I'm going to choose to be an optimist, right?
Yes.
Because the answer to this question can be very different depending on how you think it's going to be implemented or not. And so if implemented poorly, it has a non-discrimination provision where you have to treat users who opt out versus opt in. The same way, you could get disastrous results in terms of free services going away. If you think that location data is very sensitive and needs like a high standard of protection, then you can get really, really bad results there from a consumer perspective as well. But let's assume I get what I want in a privacy bill, which means that we have different tiers for sensitive versus non-sensitive data. I think the academic research in terms of consumers' willingness to pay to protect their location data, that's on the lower end. It's still moderately sensitive, but it would not get the highest standard. And so probably under my ideal privacy bill, you would not get this cost to using location data in the same way you might in a poorly written bill. So I think that's one way. And then in terms of non-discrimination, I would say that we need to allow companies to discriminate based on the economic value that the consumer data applies to the platform. Is definitely one of the avenues I see that we need to work on there.
Great. Well, thank you so much, Alec. Obviously, privacy is a big piece of the conversation and legislation that we expect to be watching over the next year. Thank you so much. This is joined by Alec Stapp from the Progressive Policy Institute. You can follow him on Twitter at Alec Stapp. That's AlecStapp. I'm Lloyd Miller, and as always, thank you so much for listening to the HPS Insights, and have a great day.
Thank you for listening to the HPS Insights podcast, produced by Hamilton Place Strategies. For the latest updates, follow us on Twitter at HPS Insight and visit us on the web at hamiltonplacestrategies.com.